Good afternoon, ladies and gentlemen. I'm John Pagan from the University of Richmond Law School, and on behalf of Gary McDowell, Terry Price, and the John Marshall International Center for the Study of Statesmanship, I'd like to welcome you to this afternoon's lecture. Our speaker, Randy Barnett, is the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center. He's one of the nation's most distinguished experts on constitutional law, contracts, and legal theory. Professor Barnett is the author of over 100 books, articles, and reviews, and he's also an experienced advocate before the U.S. Supreme Court and other tribunals. Professor Barnett earned his law degree at Harvard Law School in 1977. He was 1 year ahead of me at the law school. Chief Justice John Roberts was in the class right behind mine. So when Randy Barnett was a 3L, and I was a 2L, and John Roberts was a 1L, we spent a lot of time hanging out together and talking about the Commerce Clause. And if you believe that. Now, about a decade after Barnett, Roberts, and I left the law school, a guy named Barack Obama enrolled there. And as president, he, along with Professor Barnett and Chief Justice Roberts, played a central role in the Supreme Court landmark case, National Federation of Independent Business versus Sebelius, the Obamacare decision handed down last June. The case involved a challenge to the Patient Protection and Affordable Care Act of 2010, the signature achievement of President Obama's first term in office. Professor Barnett represented the business group that attacked the Act's constitutionality on the ground that the individual mandate, which requires people to purchase a health insurance policy providing a minimum level of coverage, exceeded Congress's power to regulate interstate commerce. Chief Justice Roberts and 4 other justices concluded that the mandate was not a valid exercise of Congress's power under the Commerce Clause and the Necessary and Proper Clause. The Chief Justice and a different set of 4 justices upheld the mandate, however, on the ground that it fell within Congress's power under the Taxing Clause. Now, unlike President Obama, Professor Barnett, and Chief Justice Roberts, I had absolutely nothing to do with the Obamacare decision, except that I teach the case in my constitutional law class. In fact, we talked about it this week. But the 4 of us have something in common, however. We learned our constitutional law from the same teacher, Professor Lawrence Tribe at Harvard Law School. And as the Obamacare case worked its way up to the Supreme Court, Professor Tribe had no doubt that the individual mandate would be held valid under the Commerce Clause. And he made the following comment in an op-ed piece in the New York Times in February 2011. Professor Tribe: "Since the New Deal, the Supreme Court has consistently held that Congress has broad constitutional power to regulate interstate commerce. This includes authority over not just goods moving across state lines, but also the economic choices of individuals within states that have significant effects on interstate markets. By that standard, this law's constitutionality is open and shut. Does anyone doubt that the multi-trillion-dollar health insurance industry is an interstate market that Congress has the power to regulate?" Well, the Obamacare case didn't turn out to be quite as open and shut as Professor Tribe and lots of other law professors, including yours truly, had predicted. And that brings us to the topic of Professor Barnett's talk this afternoon. Who won the health care case? And why did so many law professors miss the boat? Professor Barnett.
Well, thanks for that wonderful introduction. And thanks to Gary McDowell for inviting me to give this talk today. I did have the privilege, before I was one of the lawyers in the case, to be invited to Harvard Law School to debate the constitutionality of the Affordable Care Act in the Ames Moot Courtroom, which is this big moot courtroom in the law school. And my debate opponents, it was me against Professor Larry Tribe and Charles Fried, 2-on-1. This is what Harvard considers a fair contest. And both of them were my professors. Professor Tribe, Larry Tribe, was my con law professor, and Fried was my torts professor. So here I got to stand up and debate both of them 2-on-1. And you know, it was a very interesting experience. That was, and the whole thing was an interesting experience. I was involved in the case before I became one of the lawyers for the National Federation of Independent Business. In fact, I first became involved in the case before the Senate bill was passed, voted on. I'm going to talk more about that maybe during the Q&A. But now, what I'm going to do is I'm going to give this talk as I've prepared it. It is prepared somewhat with a legal audience in mind who's going to know the cases that I'm talking about on which the court was based, but I'm going to extemporaneously sort of expand and explain that because I know not all of you are lawyers. So the talk's going to go a teeny bit longer than it normally would so that I can flesh it out and hopefully make it accessible to everyone in the room. The legal challenge to the Patient Protection and Affordable Care Act, commonly known as Obamacare, which I advocated as a law professor before representing the National Federation of Independent Business as one of its lawyers, was about two big things. First, saving the country from Obamacare, which I think is a disastrous public policy, and second, saving the Constitution for the country. To my great disappointment, we lost on the first point in the Supreme Court's 5-4 ruling that upheld most of the health care law. But to my enormous relief, we won on the second point about the Constitution. Now, before the decision, I, like everyone else, thought it would have to be all or nothing at all. If we lost on Obamacare, it would mean that the government's and most law professors' reading of the Commerce and Necessary and Proper Clause would have prevailed. And if we won, it was because our theories of the Commerce and Necessary and Proper Clause had been affirmed by the court. Never really imagined it was possible to win on the law and still lose on the outcome of the case. But as it happened, although we did not succeed in invalidating most of Obamacare, our view of the Commerce and Necessary and Proper Clauses were affirmed by 5 justices. If before the case you had decided to put, if before the case was decided, you put a gun to my head and mandated that I choose one of these outcomes over the other, Obamacare versus the Constitution, I think I would have picked the Constitution, although the Obamacare is really such a problematic piece of legislation that it would have been a difficult choice. So the question, who won the case, is actually a complicated one to answer, as it depends as much on what might have been decided as opposed to what actually was. It depends on what you think the constitutional law baseline was before the decision, and it depends on how much you think any of this actually matters, how much you think constitutional doctrine actually makes any difference at all. So let me briefly examine these issues before I turn to my attention at the end to explain why so many law professors missed the boat when they dismissed the constitutional challenges to Obamacare as frivolous, as the word that was commonly bandied about. So first I'm going to do is explain the reasoning of the case, what I believe the court actually held, and what they didn't. So first, the reasoning of the case. 5 justices of the Supreme Court have now definitively ruled that the Commerce Clause, the Necessary and Proper Clause, and the spending powers have limits, that the mandate to purchase private health insurance, as well as the threat to withhold Medicaid funding unless states agree to expand their Medicaid coverage, exceeded those limits, and that the court will enforce these limits. On the Commerce Clause, Chief Justice Roberts and 4 dissenting justices accepted all of our side's arguments about why the insurance mandate exceeded the Commerce Clause power. Quote, "The individual mandate cannot be upheld as an exercise of Congress's power under the Commerce Clause," Roberts wrote. "That clause authorizes Congress to regulate interstate commerce, not to order individuals to engage in it," unquote. Roberts adopted this view for the precise reason that we advanced, the precise reason we thought he needed to adopt this view. Granting Congress this power would gravely limit the liberties of the people. As he put it, quote, "Allowing Congress to justify federal regulation by pointing to the effect of inaction on commerce would bring countless decisions an individual could potentially make within the scope of federal regulation, and under the government's theory, empower Congress to make those decisions for him," unquote. Supporters of the health care overhaul had invoked the power of Congress to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Seeing this, the Necessary and Proper Clause, as a constitutional carte blanche to adopt any means to facilitate the regulation of insurance companies that did not violate an express constitutional prohibition. In contrast, we contended that the Act's mandate was an improper means of executing the commerce power, akin to the improper means of commandeering the states that had been rejected in the Prince case. Roberts agreed, quote, "Even if the individual mandate is necessary to the Act's insurance reforms, such an expansion of federal power is not a proper means for making those reforms effective," unquote. Tellingly, he did not rest this finding of impropriety on any express prohibition in the Constitution, but instead on the threat of this invocation of power to undermine the enumerated powers scheme in Article I, Section 8, that informs the spirit of the Constitution. As he put it, quoting from both McCulloch versus Maryland and the Prince case, quote, "We have also carried out our responsibility to declare unconstitutional those laws that undermine the structure of government established by the Constitution. Such laws which are not consistent with the letter and spirit of the Constitution are not proper means for carrying into execution Congress's enumerated powers. Rather, they are, in the words of the Federalist, mere acts of usurpation, which deserve to be treated as such," unquote. From this, the Chief Justice concluded, quote, "Applying these principles, the individual mandate cannot be sustained under the necessary and proper clause as essential components of insurance reforms," unquote. For these reasons, the court held that economic mandates are unconstitutional under both the commerce and necessary and proper clauses. And yes, I do believe that it was the holding of the court. In Part 3C of his opinion, which was joined without dissent by the 4 liberal justices, the Chief Justice wrote, quote, "The court today holds that our Constitution protects us from federal regulation under the Commerce Clause, so long as we abstain from the regulated activity," unquote. Now, why the liberal justices concurred in this holding or agreed to the section that summarized the holding this way is a matter of the same sort of speculation that attends the Chief Justice's reported switch in time to save the Affordable Care Act, because it was reported by CBS News that he had originally voted in conference following argument to invalidate the mandate, and sometime later on during the deliberations changed his mind and voted to uphold the mandate. But for whatever reason, the 4 liberal justices did concur with that section. Contrary to the assertion that the Chief Justice Roberts did not need to reach the Commerce Clause issue, on his reasoning, which he gets to control, he clearly did. The opinion of the 5th Justice only upheld the penalty in the statute as a tax under a saving construction that eliminated the legal requirement to buy health insurance and replaced it with an option to buy insurance or pay the tax. And I'm going to explain all that at greater length in just a moment. In other words, he only upheld this as a saving construction. He said this, quote, "While the individual mandate clearly aims to induce the purchase of health insurance, it need not be read to declare that failing to do so is unlawful. If someone chooses to pay rather than obtain health insurance, they have actually complied with the law. They have fully complied with the law," unquote. The 5th vote to uphold the rest of the Affordable Care Act rested upon this rationale every bit as much as Justice Powell's 5th vote in Bakke rested on diversity. As Roberts himself wrote, quote, "Without deciding the Commerce Clause question, I would find no basis to adopt such a saving construction of the penalty." But putting aside what you might call technical or formalist justifications for this being the holding of the case, we have the realist fact that now 5 justices have embraced the entirety of our Commerce Clause and Necessary and Proper Clause argument. By contrast, the analysis advocated by most law professors could only command 4 votes on the Supreme Court. Now, in this talk, I'm not going to spend any time talking about the spending power part of the case, but suffice it to say that although the court had previously invalidated statutes as exceeding the Commerce Clause power, in 1995, the Gun-Free School Zone Act, in 2000, the Violence Against Women Act, not since the New Deal had it rejected a law for exceeding the spending power of Congress until now. In NFIB, the court invalidated the power of Congress to coerce states by withholding Medicaid funding for existing programs unless they accept new coverage requirements. All of what I've just told you today, all of what I've summarized so far about what this case did, represents a fundamental departure from how most law professors viewed constitutional law before this decision. So if we prevailed on all our arguments about economic mandates, how could the mandate have been upheld? Well, The answer is, and this may be an answer that comes to as news to some of you, is that the mandate was not upheld. It was not upheld. As I noted above, the Chief Justice upheld the Affordable Care Act. The Affordable Care Act was upheld by rewriting the laws, what the law called the individual insurance requirement, that's the actual words of the law, so that it was no longer a requirement, but merely an option. Get insurance or pay a mild tax penalty. Contrary to the statute, he ruled that anyone who did not have to pay the penalty would have no legal duty to get insurance. After conceding that, quote, the statute reads more naturally as a command to buy insurance than as a tax, unquote, he then affirmed that, quote, the federal government does not have the power to order people to buy health insurance. Section 5000A, which is where the mandate appears, would therefore be unconstitutional, he wrote, if read as a command, unquote. Therefore, it is because he does away with the mandate, he does away with the requirement, by means of what he calls a saving construction, that Roberts finds the penalty alone to be constitutional as a tax. Put another way, in the Affordable Care Act, the mandate was called the individual responsibility requirement. To save the rest of the Affordable Care Act, the Chief Justice essentially deleted the requirement part. So the mandate qua mandate is gone, and it was not upheld under the tax power or any other power. What's left after he eliminates the requirement is a penalty, and the penalty is then upheld as a tax. So what's the difference, you may ask? So what? Well, under the Affordable Care Act as enacted, all non-exempt Americans had to buy health insurance. They were required to. Under the Supreme Court's ruling, no American has to buy health insurance, though some Americans will pay a tax if they don't. Under the Affordable Care Act, millions of Americans who did not have to pay the penalty because they don't pay enough or any income tax were still required by law to get insurance or be a lawbreaker. Under the Supreme Court's revision, they don't. Under the Affordable Care Act, as written, those Americans who paid the penalty but did not get health insurance were still outlaws because they disobeyed the requirement. Under the Supreme Court's ruling, if you pay the tax, you're cool with the feds. Chief Justice John Roberts justified his recharacterization of the penalty in the Affordable Care Act as a tax on the ground that the amount involved was so small as to be non-coercive. It merely provided an incentive, like how Cash for Clunkers provided a $5,000 incentive to trade in old cars. Millions were lawfully free to forego the $5,000 and keep their old cars without violating the law. The court's opinion implied that if this tax became so high as to coerce compliance, it would then be an unconstitutional penalty under the tax power. Here's what the court said. We need not here decide the precise point at which an exaction becomes so punitive that the taxing power does not authorize it. It remains true, however, that the power to tax is not the power to destroy while this court sits. I just realized I forgot to turn on the microphone I was supposed to turn on. There we go. Have I been doing this microphone free or just with a different microphone, I think? Right, okay. This is much louder. I'm afraid it's too loud. Is it okay? Don't need it. I think, did they need it for the video, Shannon? Okay, thanks. It was better without it. Okay. All right. But I think what I've just said about the difference between what the court held about the penalty and what it rejected about the mandate is not even the most important part of why it makes a difference. Why it makes a difference that they converted the individual insurance mandate into a tax on failure to buy insurance. Under the court's ruling, Congress is not free in the future to supplement the monetary penalty with punitive fines or jail time. Had the argument that the mandate was a constitutional regulation of interstate commerce under the Commerce Clause been accepted by the court, as it was by the 4 liberal justices, future Congresses could jack up the amount of the penalty and add prison time to boot. So here's another way to appreciate the difference between what the court actually did and what they were being asked to do by the government and by most law professors. Consider the Controlled Substances Act, which is what makes drugs illegal throughout the country under federal law. I was one of the lawyers that represented Angel Raich in the medical marijuana case that came out of California. I argued that case in the Supreme Court. We lost that case 6-3. But what we argued in that case is that it was beyond Congress's power to regulate commerce to reach into a backyard and tell an individual what they could grow in their own backyard and consume in their own home. In the case of my client, Angel, she was ill. She had 2 caregivers growing marijuana for her. They gave it to her at no charge. In the case of my other client, Diane Monson, she grew the marijuana for herself in her own backyard and consumed it to alleviate excruciating back pain that she experienced. And we lost that case because, in fact, the Controlled Substance Act was upheld as a valid exercise of Congress's Commerce Clause power, even though we think this was Congress only has the power to regulate commerce that goes between states or interstate commerce, and yet they can reach down into your backyard and tell you what you can grow and consume on your own property. We lost that case 6-3. And it was upheld under the Commerce Power. Now suppose the Controlled Substances Act was only constitutional under Chief Justice Roberts' theory of the tax power. If that were true, we would have to open up the prisons, federal prisons, and release tens of thousands of individuals who are being held there for violating it. In fact, any of you in this room, under that theory, if that was the way that statute was justified, could legally smoke marijuana without being subject to sanctions, criminal prosecution, or if you're a lawyer, disbarment, provided only you were willing to pay a small tax on that activity. And that's a big difference. That is a big difference. And that's what we got out of this case as opposed to what the other side was asking for. But in the end, you may ask, realistically, how much does this improvement in assuming you accept my characterization that this is an improvement in constitutional doctrine, how much does it really matter? Doesn't the NFIB case really mean that the Supreme Court will seek to uphold a federal law by hook or by crook? Would it ever adhere to this doctrine if it really made a difference in a big constitutional case? Was this merely what some call symbolic federalism? Now, I think the answers to this are a matter of speculation. There is no real right answer to these questions. But in response, let me just offer the following. Constitutional doctrine, for what it's worth, severely constrained us in our challenge to the Affordable Care Act. We might have liked to contest the constitutionality of imposing requirements on the insurance companies, mandates on the insurance companies that's outside the bounds of the original meaning of the Commerce Clause. Why? Because insurance wasn't considered a species of commerce at the time the Constitution was enacted. And it wasn't for almost 200 years, or at least 150 years of this country's existence. It was only in the 1940s that the Supreme Court, in a case called U.S. v. Southeastern Underwriters, held that Congress could regulate insurance under its Commerce Clause power. So we might have liked to contest that, but except we had this precedent, U.S. v. Southeastern Underwriters, which said Congress can regulate insurance under its commerce power, so we couldn't contest it. In other words, the doctrine constrained what we could do in court. We just couldn't ever make that challenge, so we didn't make that challenge. And now consider this. Suppose Congress were now to amend the Affordable Care Act as it's being asked to do by insurance companies who think that this penalty imposed for not having insurance is so low that it's actually not going to get many people to buy insurance, and now they're going to be left holding the bag, so they're actually lobbying Congress to try to get them to do more to get people to buy insurance. Supposing now, in response to that, Congress decides to amend the Affordable Care Act to impose a criminal sanction on the failure to purchase health insurance. Supposing it did that, would law professors now dismiss a challenge to that as frivolous? I don't think so. I think most district and circuit court judges would invalidate that law without missing a beat. Would the Supreme Court uphold it or would it reverse? I think it would uphold it without missing a beat. In other words, that not only shows that what we did was significant, but it also shows it was the holding of the case. That is, I think, basically, no lower court would uphold that kind of a law. Now, of course, it's always true that a change in the justices could negate the importance of the NFIB decision, and justices can call it a holding or a dictum, or they can do whatever they want with it. But that can happen with any doctrine. You have a change in the composition of the court, they can decide to follow the law that they had, or they can decide to change it. That always happens. But if you ask any person who litigates whether the doctrine matters, at least so long as it survives, and long as the composition of the court is what it is, I believe the answer they'll give you will tell you that the doctrine that was established in the NFIB case matters also. All right, so now you have an idea of what I think the case did, what it actually accomplished, what it held, what it said, which we may not have known because you kind of have to study the case. And a lot of people said, well, and I think inaccurately, that it just was the power was just upheld under the tax power, which I think is not accurate, as I've explained. Why did most law professors believed that the individual insurance mandate in the Affordable Care Act was so obviously justified by the commerce and necessary and proper clauses that there could be no serious challenge to its constitutionality? You already heard a quotation from Professor Tribe, who made that point, as well as many people. I mean, this is a paper, this is an article, talk that's based on an article, and I now have a string cite that's over a page long. That is a footnote that goes itself 2 pages, which just lists quotes from law professors who basically say there's no reasonable argument that sustains this challenge. In a poll conducted by the American Bar Association, for example, 85% of experts predicted that the Affordable Care Act would be fully upheld. And by the way, they can't have been 85% of law professors, because if I actually had 15% of law professors on my side, I would have been very happy. They got 14% somewhere else. These are other experts that are not themselves law professors. Indeed, some law professors went so far as to call the constitutional challenge that we were arguing for frivolous, and one even warned that he, quote, fully expects the lawyers who signed the briefs to face a motion for Rule 11 sanctions, and if they appeal to a federal court of appeals for costs. In other words, they would actually be sanctioned for signing the briefs. He was cautioning, this was a professor then at Florida State, cautioning the lawyers who work for the Florida AG's office that if they signed the briefs in this case, they would be subject to federal sanctions for having brought so frivolous a case. He's now on the faculty at Boston College. So why did the law professors get this so wrong? Now, first of all, several law professors, such as my friend Jack Balkin from Yale, thought that the mandate could also be justified under the tax power. But no one who believed that, a lot of law professors thought that, but no one who believed that also said publicly that it was only justified under the tax power and was unconstitutional under the commerce power, which is what the court eventually decided. And only 2 professors I know, Neil Siegel and Robert Cooter, both writing together in one paper, saw that to uphold it as a tax, Section 5000A would have to be rewritten to eliminate the express requirement to buy insurance, which is, say Americans shall buy insurance, to eliminate the shall and make it an option. They actually outlined that possibility in a paper that got posted online, and I strongly suspect, though I don't know, that that's where Chief Justice Roberts got the idea from. He got the idea from these 2 law professors. But even they didn't say it was unconstitutional under the Commerce Clause. They only said, here's a way the court could do it if they wanted to do it this way. So why did so many law professors get this case so wrong? Well, part of this, of course, is that law professors largely exist in an ideological bubble in which folks like me, and some of you may wonder, what does that mean? I'm generally politically libertarian, and also I would include in this conservatives. Folks like me are either non-existent on their faculties, or we can just be dismissed as marginal because we're so few in number. But I don't think that's the whole story. That's true, but I don't think it's the whole story, because after all, even some politically conservative law professors accepted the consensus view that the Affordable Care Act would be easily upheld. I believe most law professors missed the boat in this case because they have never properly understood what's called the new federalism that was adopted by the Rehnquist Court back in the 1980s and 90s. So in the balance of my remarks, I'm going to try to explain that. I'm going to try to explain what I think the Rehnquist Court was up to and how law professors have misconstrued that. And because they misconstrued that, they didn't adequately appreciate the strength of our argument. Most law professors share what my colleague at Georgetown, Larry Solem, has called the same constitutional gestalt. By constitutional gestalt, I mean sort of a general worldview in which they sort of use to navigate themselves when particular issues come about. So I'm going to use this term gestalt to describe this worldview. And it's a gestalt about the meaning of the New Deal, the meaning of what law professors call the New Deal settlement. What was settled when the New Deal Court and the Warren Court expanded federal power? That has been settled, but what are the terms of that settlement? The prevailing view, to oversimplify the prevailing view, is that most law professors think that the New Deal and the Warren Court rulings, expanding congressional power, established that the commerce and necessary and proper clauses give Congress a power to regulate the national economy at its discretion, a plenary power to regulate the national economy at its discretion, subject only to the express prohibitions in the Constitution and perhaps to some selected unenumerated rights, like, for example, the right of privacy. That's the prevailing academic gestalt, and it was right up until 1995 when the court decided the United States versus Lopez case. The United States versus Lopez case involved the Gun-Free School Zone Act, which made it a crime to possess a gun within 1,000 feet of a school, regardless of whether that gun had moved in interstate travel or whether any transaction had taken place. Just mere possession of a gun within 1,000 feet of a school was made criminal by statute. In the United States versus Lopez, the Supreme Court invalidated that law because they said it was beyond Congress's commerce power to do that. And that argument, and what the court essentially said there, here's where I'm sort of expanding my talk to explain to you this case that you may not have read yourself. What the court basically said, when Chief Justice Rehnquist was the one who authored this opinion, it was a 5-4 decision. What the court said was that in all the history since the New Deal, every time that we had upheld a Commerce Clause regulation, the activity that was being regulated was economic in nature. And since possessing a gun is not economic, it's non-economic, that goes beyond anywhere we've been before. That goes beyond anything we've authorized before. And to authorize this would be to undermine the enumerated power scheme that is described in Article 1, Section 8, and it violates what Chief Justice Rehnquist called the first principles of our constitutional government. And that's what happened in 1995. This decision by the court in 1995 was considered to be heretical by law professors. They were screaming about this decision. Now, at the time this happened, some dismissed it as aberrational and a decision that ought to be reversed as soon as possible. Some still think that. Others rationalized the distinction that was adopted by the court between economic and non-economic activity as identifying the outer boundary of that power to regulate national economic activity. So they sort of internalized it and said, oh, well, that's consistent with our gestalt that Congress can regulate anything pertaining to the national economy. And this is just saying, well, outside of that is non-economic activity. It's not relating to the national economy. Therefore, so they internalized it within their gestalt. And still others may have thought that this aspect of the new federalism had actually been rejected by the court when in the Raich case, that's the medical marijuana case I took to the court, we lost that case 6-3 when Justice Kennedy and Justice Scalia, who were in the majority in Lopez, they crossed over to the majority and upheld the application of the Controlled Substances Act to growing something in your backyard, and people interpreted that movement by them as perhaps representing the end of the new federalism of the Rehnquist court because now the two of its members had basically given up on it and joined the other side. In the meantime, the 3 votes that we got in the Raich case were from Chief Justice Rehnquist, Justice O'Connor, and Justice Thomas. Chief Justice Rehnquist passes away, is replaced by Justice Roberts. Justice O'Connor is replaced by Justice Alito. Neither Roberts nor Alito have been really much on record up till now on what they think about the Rehnquist court and what they think about the Commerce Clause in particular. So it's easy to imagine that now Scalia and Kennedy have gone over, and we don't know about Roberts and Alito, but perhaps they've given up on it, and that would just leave Justice Thomas, who would be the lone person who we might be able to get. So if you held any of these views, if you held the view that it was wrongly decided and should be reversed, if you held the view that it could be internal, it could be just absorbed by this general gestalt that Congress can do what it wants, or if you held the view that the court's actually given up on the new federalism altogether, then for you, the Affordable Care Act was an easy case. Because after all, the Affordable Care Act did represent a comprehensive scheme to regulate a huge portion of the national economy. It satisfied that. And the individual insurance mandate was both necessary to this scheme, as it was, and did not violate any express prohibitions of the Constitution. So if that's what you believe, that it was an easy case, end of story. Then what law professors thought was, and this is, I think, the part that they got wrong, that anyone who suggested anything to the contrary must be advocating the undoing of the New Deal settlement and a return to the way the things were before the New Deal, because that's the only alternative to how they interpreted what the New Deal represented. A return to what's sometimes called the evil Lochner era. Now, I actually do myself advocate returning to the pre-New Deal state of Commerce Clause and Necessary and Proper Clause law, something like that. That is the protection and holding Congress to the original meaning of its enumerated powers. I do not favor returning to the pre-New Deal state of civil rights laws, but I do favor returning to the pre-New Deal state of Article I, Section 8. But that wasn't what was at issue in our case. And that's not what I'm about to talk about. I'm not going to talk about that. The law professors thought, look, it's one or the other. You either accept, it's either our view of the New Deal, or you're going to go back to this other vision of federal power, which I myself personally advocate. What law professors have missed is the possibility of an alternative interpretation of the New Deal that comprises what you might call a third constitutional gestalt. And it was the gestalt that informed our whole litigation strategy. And it's this: all powers that were approved by the New Deal and Warren courts are now to be taken as constitutional. But any claim of an additional new power still needs to be justified. Put another way, the expansion of congressional power authorized by the New Deal and Warren courts represents a new high watermark of congressional power. But to go any higher than this requires special justification. This gestalt could be summarized or labeled this far and no farther, as long as you realize that by no farther, I don't mean that in an absolute sense. I simply mean as establishing a baseline that beyond which requires serious justification before it will be upheld. Now, it is this gestalt that is why the general acceptance of our claim that the individual insurance mandate was unprecedented, a claim that I started to make in November of 2009 before the bill actually came out of the Senate in December, and a claim which I actually got from the Congressional Research Service, which had given a report to Congress saying that using the word this is unprecedented. That's where we got it from. So I had some confidence that it actually was unprecedented when I first started arguing it. This is the reason why when we called this claim of power unprecedented, it made such a big difference to the outcome, to the successful outcome of the case for us. Because if you accept our claim that the mandate was unprecedented, that would then put the burden on the government to justify its use in a way that they normally don't face. And that brings me to a second tenet of the constitutional gestalt of the Rehnquist Court's new federalism, and it's this: any purported justification that's going to take you beyond what's been done before that would lead to an unlimited reading of Congress's Article I, Section 8 powers would improperly contradict what Chief Justice Rehnquist called the first principles of our constitutional order. So if the rationale that's being offered in defense of a power is actually such that it would lead to virtually unlimited power in the part of Congress, if you accept that rationale here, that's what's going to happen in other cases, that rationale will be ruled out of order. That will not be an acceptable rationale to justify an expansion of power. And that's why claims like health care is different or health care is a national problem and other similar rationales that were offered by the government and its many academic defenders fell on 5 deaf ears. All the rationales that were offered in favor of expanding the power, if accepted, would lead to a national police power qualified only by the Bill of Rights, as state police power is qualified by the Bill of Rights. In other words, national power would be the same scope as state power would be. And that was contrary to the constitutional gestalt of the Rehnquist Court's new federalism. Now, assuming you accept this description of the Rehnquist Court's constitutional gestalt. Remember, I'm not defending it. I actually hold a different one myself. I'm just talking about what I think they were up to. If you accept this as a description, you may well object, well, why this far and no farther? Why draw the line at this point? Besides, where is all this in the Constitution, which is kind of rich, because where is most of anything that the Supreme Court is doing in the Constitution? I mean, where, you know, the doctrine against us is a substantial effects doctrine. It says you can reach any interstate activity that has in the aggregate has a substantial effect on interstate commerce. I can assure you that's not anywhere in the Constitution either, and yet that doesn't stop it from being a doctrine that the court has adopted. But in fact, most of what the court does is not in the Constitution because it's implementing what is in the Constitution by using doctrine that it has to come up with to make law, and that's just what it has to do to keep in business. I mean, the First Amendment, freedom of speech, is protected by laws, by doctrines that describe time, place, and manner regulations of speech, and that's all not in the Constitution, but it's the kind of thing courts have to come up with to implement what is in the Constitution. So there's nothing wrong with that, but the charge, where is it in the Constitution, therefore, is of very limited utility. So, where is it on the Constitution, and why draw the line at this far and no farther? That's the question on the table here. Well, here is where I think the growth of originalism that Professor McDowell had so much to do with since the 1980s enters the picture. Unlike the Heller case, which was the 2008 case that that interpreted the Second Amendment as protecting an individual right to keep and bear arms, unlike that case, which was argued and decided on originalist grounds, according to the original meaning of the Second Amendment, in our challenge to the Affordable Care Act, we made no originalist claims whatsoever. Our case was litigated entirely on the basis of existing doctrine. But the original meaning of the Constitution still played a role, I think, because it lies behind the Rehnquist Court's new federalism and exerts what you might think of as a gravitational force that we now see, for the first time, we can be sure, extends to the Roberts Court as well. Simply put, it's this. During the New Deal, Americans acquiesced to an enormous expansion of federal power, and the Supreme Court eventually expanded its interpretation of federal power accordingly, as it typically does. It follows the overwhelming weight of American public opinion. This expansion is now settled precedent. But with respect to the Article 1, Section 8 powers of Congress, the powers that had been upheld by the New Deal and the Warren courts violates the original meaning of the Constitution. Because this expansion was illegitimate on originalist grounds, any further expansion must be justified. That's what established the baseline. That's what creates this gravitational force. Because you're deviating from the original meaning of the text, if you go farther, you better have a pretty good reason for it. And any purported justification to go farther that would essentially eliminate the enumerated power scheme that's in the text itself is improper, is simply improper. And that's, by the way, was the reasoning of Judge Vinson in the District Court of Florida. That's what he said, why it was improper. Now, of course, many, if not most, law professors reject this gestalt that I've just described, this Rehnquist Court gestalt, in favor of the gestalt that reads the New Deal as establishing something like a national problems power. It gives Congress the power to address any national problem. Many also reject the analysis of the commerce and necessary and proper clauses that's in Chief Justice Roberts' opinion and the opinion of the four dissenters, and would like to dismiss it, for example, as dictum as opposed to holding. But I think if we're to understand the NFIB decision and the new federalism cases that preceded it, we don't do so accurately unless we take into account this alternate reading of the New Deal settlement that animated the Rehnquist Court, and we now know also animates the Roberts Court. That's what we didn't know before, for the reasons I already explained, but now we do know. Given that the actual holding in the NFIB case is that Congress may never do in the future what it's never done before, which is impose economic mandates on the people. Let me just stop for a minute and just clarify that. During the 2.5 years run-up to the lawsuit, I was debating many people. You already heard I've debated. Some of the people I've debated, I was going around the country. I was doing a lot of television and radio, and I was doing a lot of talking about this. And a lot of times what I heard from the other side was that if our side were to prevail, it would mean the undoing of federal power, the undoing of Social Security and Medicaid and all the powers that Congress had used since the New Deal. It would represent the undoing of that. My response to that at the time was, no. We are arguing that this one power, the power to compel individuals to engage in economic activity with private companies, which has never been exercised by Congress before, that is, it means it's unprecedented. If we win, it'll mean that this power that they've never exercised before, they may never exercise again in the future. That's all. Everything that currently exists will continue to exist. Every power that's being exercised will continue to be constitutional. That was what we said. And in fact, by the way, if that weren't the case, we would never have had much of a shot in front of the Supreme Court because what we were arguing for was so limited. But the other side said, no, 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 if we win, the sky will fall. Immediately after the case was decided, those same folks were looking at the reasoning I just told you about. They said, well, you know, it's not really a very big deal. It only applies to economic mandates. Congress has never done it before. They're never going to do it again. It's really not that big a deal. Well, they're right. I'm not going to change my tune. It means it has the scope that I thought it had before. It is a big deal and would have been a big deal if we'd have taken down the Affordable Care Act entirely, because it would have represented that there are limits, that this exceeded those limits, and the courts will enforce those limits, and that goes against what most law professors have taught. But in terms of what the Congress could do or not do in the future, it wasn't going to be a very big opinion. It was never going to be a big decision. If we'd won everything, it wouldn't have been any bigger a decision than it is now. But so given all that, it may turn out that the most significant aspect of the outcome of this case is that it proves, when none of us really knew for sure, that the new federalism of the Rehnquist Court still has 5 votes. And establishing that and achieving that and preventing the repudiation of that, which is what the other side was advocating, was an important victory for constitutional government. So in that sense, I think we won the case. Thanks. So I guess I'm empowered, or I'm to take comments or questions from you. And this session goes to 5:30. Is that right? So we have about 15 minutes, and I'm happy to talk about what it was like to litigate the case, any aspect of it you want to talk about. Yes, sir.
Professor Barnett, I can understand that you're tickled to death that your arguments prevailed and that most of the law professors in the country were wrong. It doesn't follow from that, however, that all those law professors are fools and that the Supreme Court is somehow or another enlightened.
I didn't hear it's the Supreme Court is
enlightened.
It is enlightened, okay.
It could be the other way around. The Supreme Court, at least 5 of them, could be fools, and all of the law professors could be enlightened. Now,
that's certainly a logical possibility.
Now, I happen to be an old-fashioned person. I believe in the rule of law. And I would like to think that on the basis of either the Constitution, its original meaning, or on the basis of all these Supreme Court precedents, that there is some criterion, some standard, some rule by which courts could decide what Congress can and cannot do in terms of regulating interstate commerce or the economy. Now, is there such a rule, criterion, standard, or not? And please don't tell me that the rule is this far and no farther. That certainly doesn't cut it as a rule of law. Can you give me a rule of law with respect to what the Interstate Commerce Clause allows and does not allow?
Well, let me begin by saying that I think the way I concluded my remarks was in no way to disparage my colleagues as law professors. It was to explain how they all consistently got it wrong. And because I believe not just because of ideological bias. Remember, I raised that as a possibility and then I dismissed it. Well, I diminished. It's not totally dismissed it, but I discounted it. It was because they have a particular worldview about what the New Deal represents, and I think that worldview is inconsistent with what the Rehnquist Court had been up to. And so I just want to say that I didn't say that they were fools, and I personally don't think the Supreme Court is all that enlightened. And so I hold neither of those views myself. Now, if you want to know what the rule of law is, there's 2 ways to approach that. One is by looking at the doctrine. For example, in the Lopez case, the court drew a line and said that if Congress was trying to regulate wholly intrastate activity that was non-economic in nature, then it couldn't do that. That's what it said in Lopez, and that's what it said in the Morrison case in 2000. So there's a line for you. And so that's one of the lines that there is, that's in the doctrine. Now, the problem we had in this case is that we had a case of first impression. This is the problem with trying to apply doctrine this way, and that is this has never been done before. Congress has never tried to compel all people in the country to do business with a private company or pay a fine. They've just never done it before. And I can prove to you they've never done it. First of all, no one ever came up with an example of where they had done it before, but I can prove to each one of you that it's never been done before, because if it ever had been done before, you would know the contracts that you were compelled to enter into with private companies or pay a fine to the federal government or have some fine deducted against your refund against your taxes, which is how this works. You would know about that. But none of you can cite any such duties that you're under because it's never been done before, and your parents never had to do it, and your grandparents never had to do it. So it's never been done before. And if you're talking about a case of first impression, then there isn't a clear doctrine that's going to cover it. Now, I never said, when I litigated this case and when I argued this case, that this case was a slam dunk case for me. It was the other side who claimed it was a slam dunk case for them. As long as you have a case of first impression, it can go either way, depending on what. And here I have to do what you told me not to do. I have to appeal to the overall gestalt of what the court is up to. Because I actually think, as a litigating attorney, that is a better way, a more accurate way of predicting what courts are going to do or not do than some particular doctrine, especially when there's no doctrine in place to cover the situation that you're talking about. And that's why this far and no farther is a better explanation. It's two principles. One, this far and no farther. And secondly, if you want to go farther, then you're going to have to come up with a justification that does not lead to an unlimited power in Congress. The other side failed to do that. They failed to do that at every stage of litigation, including in the argument in front of the Supreme Court itself. They never identified what you might call a limiting principle that could not have been used in the next case to justify another power and another one after that. And because they failed to do that, they didn't get 5 votes. So in that sense, I think what I was explaining to you about this far and no farther, but said more specifically as I explained it, does explain what happens here better than the particular doctrines. Now, I do think my own preference is to enforce the original meaning of the Constitution, because that's something in writing, and that's something we can ascertain the meaning of. And if we were to enforce that, this case would have been an easy case, because insurance is simply not within the original meaning of commerce, and Congress would have no power over insurance, as it didn't have for 150 years until 1944, and then it had that power. So that's my preference. My preference is to follow the meaning of the text of the Constitution. But that when you litigate under this in front of this unenlightened Supreme Court, you can't do that unless you're in a territory that has never been decided before, like the Heller case, litigating the meaning of the Second Amendment, which had not previously been decided by the Supreme Court. And at that point, the court reverted to the original meaning of the text. Yes, ma'am.
I just kind of wonder what you think about the President and Congress, and do you really think that their intention was for the individual mandate to have criminal penalties? And I guess if you think that it was or it wasn't, do you think that when some insurance company asked for further penalties, that they would not have then looked and said, oh, we didn't intend for it to go that far? Do you think it would have been self-limiting, or do you think they would have?
Okay, now I'll tell you what I think. I've asserted this many times in debates with people on the other side, and no one's ever really contradicted me from the other side, and that is, I don't believe this bill was ever intended to become law. It was never intended to become law. It was intended to get 60 votes to get out of the Senate, because they were stuck in the Senate. The House had already passed a version. They couldn't get out of the Senate. They needed 60 votes. They had exactly 60 Democratic votes, and they couldn't get to 60. And that's when they started going the Cornhusker kickback and Gator aid to Louisiana. And the Gator aid was to Florida, and the Louisiana Purchase was to. These were payoffs to senators or benefits to senator states that was going to get their vote. And the idea was, the object was to get out of the Senate with 60 votes. It would then go into conference with the House. They'd write the real bill, the bill they actually wanted, which wasn't this one. And then when they went back to the Senate, once they were on record, they'd still have 60 votes for whatever came back. That was what was up. And the only thing that what threw a monkey wrench in that was the election of Scott Brown, the death of Senator Kennedy, and the election of Scott Brown in Massachusetts deprived the Democrats of 60 votes, which meant they couldn't go back to the Senate with a changed bill. The problem the Democrats then faced was very few Democrats like this bill, especially Democrats in the House. What Democrats really wanted, and what health care reform people on that side of the aisle really want, is single payer. And this bill isn't that. The last thing they wanted was a big coercive payoff to the private insurance companies, where they're going to recruit and coerce American citizens to do business with private insurance companies. That's not what they wanted. They wanted a single payer plan. But then they couldn't get it. They had to choose, swallow this or get nothing. It took them a long time before they got all their ducks in a row. It took till March 23rd before they got all their ducks in a row, and they finally decided to swallow it. So if you ask me what they intended, I think the answer is they didn't intend this to become law. And now we're all stuck with this thing that they never intended to become law because they got stopped in their tracks by the voters of Massachusetts, of all places, and weren't allowed to go any farther than this law was. Yes, sir.
A question about something that I didn't hear you talk talk about, which was severability, which was a big issue in the case, and there was a whole argument devoted to it, right? So the idea, right, is that the individual mandate is just one little piece of this whole thing that has to do with, health care for Indians and just all sorts of things. And you said you had two goals. One was to enforce the Constitution. The other was to take down Obamacare.
Right.
Severability was the piece of the puzzle that would allow you to move from that second goal of taking down the Constitution to taking down the whole thing. Two questions. One has to do with Chief Justice Roberts, because I think Jane Crawford Greenberg was probably right in her reporting. And her reporting was that he voted to strike it down, but that there was no consensus about severability at conference. So one thought, so the first question is, what's your reaction to the suggestion that maybe the challengers overplayed their hand? That is, by pushing severability too hard, realizing that maybe they have to take down the whole thing on the basis of a new limiting principle and one vote, that was just not judicial, to the extent that courts are constantly making new limiting doctrines, that this was not the situation to make new limiting doctrine. That's number one. And number two is, supposing that the severability doctrine is not part of the original judicial power, would that be something, nevertheless, as an advocate trying to enforce the other parts of the Constitution, you would push?
I'm not sure I understand the second part of that question, so let me just address the first part. I don't see how, I mean, I don't see how we could possibly have overplayed our hand. I mean, first of all, it was the only means, and it is the only means, to take down the whole act. There's another challenge out there now which could take down the whole act, which I could talk about in a minute, but you know, I'm not going to speculate on the chances of its success. I never speculated, by the way, on the chances of the success of this theory, frankly, publicly. I never said what I thought we were going to win or lose. So I don't think we had any choice but to make this argument. I don't think we overplayed our hands. It was always within the power of the justices to say, okay, the individual mandate's unconstitutional, but it can be severed from the rest of the act the way the government had argued. The government had argued how it could be severed from the rest of the act. They argued that it was that much of the act would have to go. Much of the act would stay, but a good part of the act would go. In fact, what the government said in argument was that all the insurance company regulations would have to go, but the rest of the bill could be okay. They had that position available to them. They always did. If they found that position, it doesn't matter what we said. If they found that position persuasive, they could have always held that. Chief Justice Roberts could have held that. He could have said the individual mandates is completely unconstitutional, as are the insurance company requirements that are linked to it, you know, inexorably linked to it, and the rest of the bill stands. He could have said that. He chose not to. I don't know why he chose not to, but he chose not to. And here's the reason why the government was in a bind on the severability issue. Because the justification for the constitutionality of making you buy insurance is that it is essential to make the scheme work, that there can't be free riders. You can't have insurance for pre-existing conditions that you can sign up for when you go on your way to the hospital. The whole system will fall apart if you have that. So it's absolutely essential to our scheme that you be required to sign up in advance, and therefore that's why it's constitutional. So on the one hand, they say they absolutely have to have this in order for it to be constitutional. On the other hand, they were not in a position to argue, well, you could just do away with it, and the rest of the bill would function just fine. They can't say both things at the same time. And then the government didn't say both things. They basically said, no, all the insurance company regulations are going to have to go. But there's a lot of other stuff in this bill that could stay. So why it broke down, I mean, I think, according to the reportage we have, Jan Crawford's reportage, 4 justices thought that the whole bill had to go down. 4 justices would have upheld the whole bill, and for some reason, Chief Justice Roberts had initially voted in conference to strike down the mandate. There may not have been, there probably wasn't, any consensus on severability, and eventually he decided to do this. But that's up to them. It's always up to them. So I don't know that there's a possibility really of overplaying our hand. I mean, what are we going to do? Say, no, just take down the mandate and that's it? Then we wouldn't have accomplished anything. And we wouldn't have accomplished any more than we actually did accomplish. Yes, sir.
Just goes to the second part of the question.
Okay.
The traditional understanding of judicial review, go back to Marbury versus Madison, is a court can't enforce a law that's unconstitutional, right? And so normally what would happen is someone would get sued for not, someone would get punished for not having insurance, and they would say the law is unconstitutional, maybe they win that, but it has no effect on health care for Indians or any other provision of the law. So the idea would be if this idea of reaching out and taking down provisions of law, some of which could even be challenged in court, was sort of inconsistent with the Article 3 itself. Is that something that an advocate who professes original meaning would...
Look, let me just begin by saying none of this case was based on I do profess original meaning. If I was allowed to argue it in front of the 9 justices, I would say the entire bill is unconstitutionally beyond Congress's power, the whole thing. But that's not on the table. That was not what we argued. So as for severability, cutting the severability cord in some, or drawing the line in some other place, the court was always free to do that. The government itself proposed a way of doing it, and the court and Chief Justice Roberts chose not to take that avenue. Why he did, I have no idea. Why he did it, what he did, as opposed to that. Yes, ma'am.
Even after this is all said and done, there is still going to be supposedly 30 million people in the country that are going to be uninsured. My question to you would be, do you see Congress taking any initiative to bridge that gap and get everyone covered to achieve universal coverage? Is there any way that
I don't believe, how can what you say be true? Why did we just, how could that be true? I mean, I just don't understand. The Democrats controlled both houses of Congress, and they had the presidency, and they passed this law to get universal coverage. And I don't think, how could it be true that 30 million people are still going to be? Is that possible? We did all of this for nothing. We took over the whole. We've taken over private insurance companies and made them into regulated public utilities and tell them how to do their business. And we're going to start dictating the kind of medical procedures people have to have covered and the kinds of how much payment people are going to get. We did all of this, and you're telling me there's still 30 million people that are uninsured? Are you kidding?
No, I'm not kidding.
Well, I'm just baffled. I don't understand. I just don't get it. I mean, why did we just do this? Maybe someone else can explain this, but this is completely mysterious to me. Yes, sir.
Are there any general limits to the idea of saving construction?
I mean, there is doctrine about saving constructions. I can't say that I was ever an expert. I mean, one of the things when you get involved in litigation, you have to learn a whole bunch of stuff you never even heard of before. And remember, I started off as a criminal prosecutor. I guess that wasn't part of the introduction, was it? I used to actually start off as a criminal prosecutor in Chicago, prosecuting murders, rapes, armed robberies. I've kind of learned a lot since then about a lot of different subjects. But there are rules that govern saving constructions. And one of them was thought to be that you have to basically choose between 2 natural readings of a statute, not one that's the natural reading of the statute and one that isn't. But that's how he decided to do it. And I actually don't know what the limiting principle of this approach is. And this may very well be this day and this train only. That is, this is the way he got out from under the freight train that was, speaking of train metaphors, he got out from under the train that was headed his direction, this way. And this would be a very dangerous thing in the future if courts could just rewrite statutes to make them constitutional that Congress never wrote. And yet he was able to claim that power because he's the Chief Justice and he can do what he wants, and he did it. And he got himself out of the way. I mean, one of the things that, since I mentioned that I was a prosecutor, one of the things that's different about litigating in the Supreme Court versus litigating in the Circuit Court of Cook County. I mean, how many of you have heard of Cook County? I mean, the president's supposed to be from there. You know, there's some corruption that's been associated with Cook County. And when I was there, not only was there corruption, but one of the groomsmen at my wedding, who was somebody who I got sworn in with as a prosecutor on the same day, I thought he'd become a corrupt lawyer, but it turned out he'd actually become an undercover agent for the FBI investigating corruption in the Circuit Court of Cook County. And eventually it was called Operation Greylord, and it broke open, and a whole bunch of judges went to jail for corrupt activities. And they happened to be a lot of judges I knew about because Terry and I had come up through the system together, and he fingered for the feds exactly the guys I knew were taking money and deciding cases on the basis of influence. So it was an interesting place to be a prosecutor. I learned a lot about what life in the real world is like when I was a prosecutor. And it turns out, but I will say this about being a trial lawyer, a prosecutor in Cook County. When a case went to the jury, once a case went to the jury, and the case was submitted to the jury, I got to go back to my office and start working on other cases. Or, in some cases, I got to go to the bar next to the courthouse and have a soda pop. But I didn't have to worry about jury tampering after the case was submitted. In this case, in the Supreme Court of the United States, the Chief Justice says at the end of oral argument, the case is submitted. So I went back to my office and I did some press, and then I figured I was going to move on to other things. But then a huge public relations campaign, I'm not saying coordinated, but it was just the spontaneous outpouring of venom towards the 5 conservative justices for having the temerity at oral argument to question the constitutionality of the president's signature legislation. It started the day after Tuesday's argument on the individual mandate with columnists like E.J. Dionne. It moved on to Maureen Dowd in the New York Times. The President of the United States opined on Monday following the Friday conference vote that this would be unprecedented in the history of the country if the court were to reverse a democratically adopted bill, adopted by a majority of Congress. I mean, that just was actually so incoherent a statement that on Tuesday, the White House had to issue a different, correct, more accurate statement, because his initial statement was just factually untrue. Of course, it's not unprecedented for courts to invalidate laws that have been passed by a majority of Congress. That's what they do, right? So that couldn't have been right. The chairman of the Senate Judiciary Committee, in a floor speech, cautioned the court and the Chief Justice in particular not to behave in this way, and what was it that people were saying to the court? Were they arguing the law? Not anymore. Not anymore. What they were arguing was 5 Republican conservative justices should not be invalidating a law that was the signature piece of legislation by a Democrat president. That's what they should not be doing. That was something that they shouldn't do. That's politics. That's politics. They were arguing political considerations should trump constitutional considerations, and they argued it vehemently from every rampart that they could get. And we know from we believe we know from the reporting that at some point Chief Justice Roberts changed his vote during the course of this. Now, you know, and I have to say that I engaged in some degree of pushback after this concerted chorus would not subside and kept getting louder and louder. Then I started writing in the press about how this would not be improper for them to do it, and other people like George Will and the editors of the Wall Street Journal had some op-eds on this, and Kathleen Parker in the Washington Post started to push back on this. But this was something that I didn't even have to deal with in the Circuit Court of Cook County. But I did have to deal with litigating in the Supreme Court of the United States. And this is the result. So I don't think that that's how we should play the game. I think everybody ought to go to the neutral corners as we were prepared to do and let the court decide, but that's not how this game was played, and it won't be how this game is played in the future. These things do have their long-run consequences, and it really wasn't pretty. Yes, sir.
Going in a little bit different direction, can you speak to your thoughts, opinions, and beliefs on how Obamacare will affect small, medium, or even big business?
Well, look, I'm not a healthcare policy person. And I learned a lot about healthcare policy in the course of litigating this case. That's one of the great things about being a lawyer. You always learn a lot about the issues involved in your client's case and your business that isn't really your business. So I'm really not the right person to ask about exactly how this thing is going to affect business or another. I mean, one of the obvious things is that there's a mandate to provide health insurance for your employees or pay a fine to the federal government. We didn't challenge that because we couldn't under precedent. But you have to be a firm over a certain size in order to be subject to the mandate. And so some firms are either laying off people to get underneath the ceiling, or they're not hiring people to stay underneath the ceiling, and that's going to affect them, and it's going to affect their employees as well. So, but there's just all kinds of consequences that are going to ripple out as a result of passing this bill that I think was never supposed to become law. Yes, sir.
Given your comments about the political side of this too, makes me think that perhaps the resolution was doubly clever, because as you're suggesting, there are some established constitutional limits here, or the affirmation of the new federalism, and on the political side, what Roberts accomplished was a situation where he made some progress legally, but he didn't force the Supreme Court to take the political heat by declaring the whole thing unconstitutional in an election year. I mean, I can't imagine what would have become of that decision in an election year. So, I mean, am I assigning too much cleverness to Roberts?
Well, I think
political and perhaps in longer term, the legal argument as well.
You're not alone in attributing cleverness to him. There were some conservative commentators that immediately thought he was being very clever, the way John Marshall had been clever to invalidate the Judiciary Act and say, you know, we say it's unconstitutional and therefore we don't have to compel the Secretary of State to deliver the commission to Mr. Marbury, and therefore we don't have to face the defiance of President Jefferson. So that was considered to be very clever, and people analogized what John Roberts did to what John Marshall had done before. And, you know, I guess cleverness is in the eye of the beholder as to whether you think that's a good thing or a bad thing. I think, my own view, I think I made it clear. I think not following what even your constitutional law is, that you state in your own opinion, because out of political considerations, which has to do with the so-called legitimacy of the court, which are based on political considerations, is not what a justice. That's not why we give these guys life tenure for. We give them life tenure to call balls and strikes, as someone once said, and that's I think. Too bad that he decided to do this. And I also think in terms of what would have happened in an election year, I think you have to keep in mind that this bill was extremely unpopular. It never polled positive, ever. From the day it was passed until the day the case was decided, it polled more than 50% unpopular. 60 to 70% of the American people anticipated that the court was going to find it unconstitutional. Whether they were right, whatever they were getting their perception from doesn't really matter. All that matters is they wouldn't have been at all surprised if the Supreme Court had struck it down. They expected the Supreme Court to strike it down. People were actually quite surprised that they didn't. So you have a bill that's majority unpopular, and you have a bill where the majority of the country thinks it's going to be held unconstitutional. I agree. The faculty of Harvard Law School and Yale Law School were going to be outraged, and the editorial board of the New York Times and the Washington Post was going to be outraged, and a whole bunch of commentators were going to be outraged, and we were going to hear about that. It was going to be Bush v. Gore times Citizens United is what we were going to hear. And that is what I think Chief Justice Roberts, for whatever reasons he had, was trying to get out of the way of. But I don't think that's an appropriate basis on which to render a constitutional decision, particularly in a case as momentous as this one. Remember, this is the first case in 50 years, except for one exception, that was given more than an hour of oral argument. I mean, there was the Miranda case was given more than an hour oral argument. It was 6 hours spread over 3 days of oral argument. It was because of the momentousness of this, and at that point we're going to say we're going to let political considerations get you out of the way of this sort of thing. I think that's wrong. But look, I understand how other people can feel differently, but I don't know that they would actually feel that differently if they were on the other side of the case. And when they're on the other side and justices don't follow what they think is the right outcome because they're worried about the pressure they're going to get, the criticism they're going to get from certain quarters, I just don't think that if you're on the other side, you're going to be all that enthusiastic about it. We have at the end of our time, but I want to give you a chance to follow up. Did you have it?
I was just going to say, I see the all or none argument, and it's certainly cleaner if it's a complete yes or a complete no, but it seems to me maybe this is a compromise, and compromises can be muddling, and maybe this is a bit of a muddle.
Well, this goes back to what that gentleman who's no longer here was saying about give me a constitutional rule of law, and compromise and muddling is not what he was looking for. It's not what any of us are looking for. But let me just end on a positive note, or a more positive note. Well, let me begin by saying, look, I come here to tell people that with respect to the law that we made, this was a good thing, and even when some on my side think it was a bad thing. In other words, they say, well, you can do it under the tax power, so it doesn't make any difference. No, that's not what happened. So here I'm coming here to talk to you about the extent to which we accomplished something good. I'm devastated. I'm still devastated by our failure to knock out the law, which is why I went through all of this exercise in the first place. So it's not like I'm a super happy camper. But if this was a political deal of the kind you've described, if it was a situation where the Chief Justice of the United States said, okay, I'm going to give the conservatives and the libertarians what they say they want with respect to the Constitution, and I'm going to give the President of the United States and his supporters what they want in terms of this law, if that was a deal that he was making, and it sure looks like one, then I'm not going to throw away the part of the deal I was given, which is the constitutional side, because I don't like the deal that the benefit that the other side got. And so in the spirit of your comment, I'm going to insist that our side claims, I mean the side that wants limited congressional power, claims the victory on that front that we got out of this deal, even if we have to suffer, we all have to suffer the health effects of being subjected to this law called the Patients Protection and Affordable Care Act. Well, anyway, thank you all for your patience. I appreciate it.